All right, so welcome to the final talk of the Fall 2020 Innovation Business and Law Center Speaker Series. I'm Jason Rantanen, a professor at the University of Iowa College of Law and director of the University of Iowa Innovation Business and Law Center. Today we welcome Professors Stella Burch Elias and Kit Johnson. Professor Elias is my colleague at the University of Iowa College of Law, where she's also the Chancellor William Gardner Hammond Fellow in Law and director of the London Law Program. Professor Johnson is an associate professor at the University of Oklahoma College of Law, which she recently joined. Prior to that, she was a professor at the University of North Dakota School of Law. And going way back, she was actually my colleague at the firm Munger, Tolles & Olson years and years ago. She was in Los Angeles, I was in San Francisco, but we did overlap for a little while. Now, both Professors Elias and Johnson teach and write and research in the area of immigration law. And today they're going to be talking about racial exclusion in employment-based immigration. I'm now going to turn it over to them. They'll talk for about 30 minutes, after which we'll have some time for questions and further discussion. So with that, welcome to Iowa Law.
Thank you for having us.
Yes, thank you for welcoming us. And thank you so much for allowing us to take part in this incredible symposium and speaker series. It's really been a pleasure to see the important topics that the IBL Center has engaged with over the course of this semester, shining light on perhaps under-researched and understudied, but crucially important areas of race-based discrimination, and racist structures in the corporate world. And against that backdrop, Professor Johnson and I were very excited to share with you this project, which is a piece of work that we are still engaged with. The project kicked off this summer with a short essay that we wrote in the Yale Journal on Regulations online symposium on racism in administrative law. And we were, to be honest, quite surprised at the extent to which writing about this topic created quite a robust and vibrant conversation in the immigration law community, because immigration law, like criminal justice, is deeply engaged with being anti-racist, considering the effect of race-based discrimination upon actors, whether it's immigrants themselves or individuals working within the Department of Homeland Security enforcing immigration laws. And it turns out that very few scholars who write in this area have turned to the equally important issue of race-based discrimination in the provision of employment-based visas. And so we feel very fortunate to have the opportunity to begin this work and to have this conversation with you today. We've prepared some slides, so I'm just going to share my screen and show you the first slide, and then I'm going to hand over to Professor Johnson, who will lead off talking to you about our project.
Thank you. I'm very excited to be here and talking with you about this topic. What you may not realize, we're not sure with the amount of focus here on IBL about the business side of law in America, is how much immigration fuels the engine of corporate America. Right? Fortune 500 companies are routinely recruiting talented managers from their offices around the world and bringing them to the United States to work in places like New York City, but all over the country. And smaller businesses in regional markets also rely on immigrant employees who are willing to fill jobs when the domestic labor market can't meet the demand. And even in rural America, there's a reliance on and a need for skilled labor, including at rural hospitals and doctors' clinics that cannot find domestic workers to meet the demand.
And so each year, approximately 800,000 employment-based visas are issued to immigrants to come and work temporarily in the United States. And even more immigrant visas are issued to individuals to come and work here in the longer term, to settle and live permanently in the US. Now, the great immigrant story is part of the American dream. And everyone knows the many historic examples of famous immigrants who've come to these shores, whether it's Levi Strauss from Germany or Andrew Carnegie from Scotland. The hagiography of the growth of America in the 19th century features these immigrant entrepreneurs. What fewer people know, though, is that even today, between 25 and 30% of new businesses formed in the United States each year are led by immigrants, whether it's Sergey Brin founding Google, Andrew Yang founding Yahoo, Andy Grove founding Intel, Ariana Huffington and the HuffPost empire, or Jan Koum with WhatsApp. Today, a tremendous number of innovative, exciting new businesses and new technological breakthroughs are led by immigrants. And in fact, nearly a quarter of US employees in STEM-based occupations are foreign nationals. And of course, I would be remiss as an immigrant myself teaching at the University of Iowa if I didn't mention that a significant proportion of academics, scholars, and scientists each year come to the United States from overseas. In short, international workers help American businesses thrive.
And while they help American businesses thrive, we still as a nation have viewed foreign-born workers, and particularly immigrants of color, with suspicion and distaste. And the long-standing animus that the United States has had towards immigrant workers and immigrant workers of color in particular has really shaped the legal structures that control immigrant employment-based migration in the United States since even the very beginning. In 1882, the Chinese Exclusion Act suspended the migration of Chinese nationals to the United States for 10 years. So a nationwide law that ended immigration from China to the United States. And this law was ostensibly enacted to protect Californian workers from having to compete with foreign laborers who, the story went, would work for lower wages. And so you see comics like this, where we have one, the Chinese immigrant being chased out. He's not making, working for too much of low wages. But in truth, if you think about it, and you look at the history about why this act was passed, it had far more to do with racial unrest in the United States following the Civil War than a desire to protect American workers. And we know this because of images like this one, where you see, as one scholar has called it, the Negroification of the Chinese worker. And you can see it visually in this picture. And it makes sense because it's hard to imagine that we would pass a federal law in order to protect low-wage earners that are really only affected in the state of California. The true reasoning behind the Chinese Exclusion Act was a nationalistic, racially motivated desire to end migration coming from China. And that's the beginning of the story of the United States' aversion to foreign-born workers of color.
And the story, of course, didn't end there. From 1924 to 1965, in an attempt to develop a slightly more progressive policy than that embodied in Chinese exclusion, the government of the United States introduced something called national origin quotas. And these quotas, which were in place for over 30 years, assured that nearly 70% of immigrant visas would be issued to natives of Northern European countries. And the goal there was cutting back drastically on immigration from Southern and Eastern Europe and maintaining formidable barriers against migration from Africa, Asia, and Latin America. And the basis for the quotas, the underlying reasoning was that the proportion, the quota, the sheer number of visas that should be allocated to foreign nationals should be based on the population currently in the United States. And so here in the Midwest, the majority of people in the United States were from Scandinavia and Germany, and therefore in the 1920s, natives of Scandinavian countries and German and Austrian citizens were entitled to a coordinate share of the visa allocation. This, of course, meant that countries that traditionally had not had large migrant populations to the United States were simply unable to obtain visas. And by happenstance, all of those individuals were individuals of color, as opposed to the white settlers who had been living for generations in the United States. And these quotas, based upon the ethnic makeup of immigrants to the United States in the 19th century, determined the immigrant flows to the United States all the way through to the 1960s. In 1965, during the civil rights movement, organizing around migration reached a peak. And the response by Congress was the Hart-Celler amendments to the Immigration and Nationality Act of 1952. And these amendments were designed to replace the national origin quotas. And if you look at the debate that happened on the Senate floor, if you look at the congressional record, it's very clear that legislators were attempting to answer the claims that were levied against them of racial animus baked into the 1952 Act. But the response was to avoid the issue in many ways, is I think the most polite way of putting it. Instead of scrapping the quotas, they introduced a different kind of quota. And the new system was a complex system designed to balance the migration of workers from countries and regions of origin around the world to create equilibrium in the racial and ethnic composition of migration flows to the United States. And this system enjoyed some success in the shorter term in that it permitted, for the first time, the entry of migrants from African and Asian nations, as well as South American countries, in a greater number than they had ever before come to the United States. But in the long term, these new quotas served as their own version of limiting factors, limiting measures, because it ensured that there was a cap on the absolute number of migrants who could come from any other country in the world. And it left workers of color from Asia and Latin America languishing on very long wait lists, struggling to demonstrate that they meet the occupational qualifications necessary to obtain a visa to come to the United States, while white applicants from Europe, Canada, Australia, and New Zealand encounter no similar barriers. And I should just say a word here for a moment about the slide in front of you. This is the visa bulletin. And each month, the State Department puts out, in this instance, this is the employment-based visa allocation. So this is coordinated with the Department of Labor, a bulletin explaining which nationals of which countries are currently eligible to apply for visas. And if the visa category is oversubscribed, when the most recent visa application that was filed is being considered. And so the visa categories are the first employment-based category, EB1, is for aliens of exceptional and extraordinary ability. So outstanding researchers and scholars, individuals who don't even need a job offer from a firm in the United States. They are so brilliant, so exceptional in their field that they are entitled to just come to the United States because we'd be lucky to have them. The second category, less outstanding, more suitably qualified, individuals with graduate degrees and a degree of professional standing and experience, where they have an offer of employment from a US corporation and they can demonstrably indicate to the adjudicator that they are well qualified to migrate to the United States. They will earn a high salary, they will pay their taxes, they will contribute. The third category of worker is usually individuals with bachelor's degrees or otherwise skilled or qualified workers. And just 10,000 visas are set aside for individuals who are unskilled workers, doing all of the jobs that we stereotypically assume low-income migrant workers come to do. So just 10,000 visas each year for individuals taking on those kinds of jobs. The fourth category of workers are usually religious workers, so priests, rabbis, imams, and individuals who've worked in US consulates overseas. And then the fifth category is the favorite of every student I teach. It is the so-called millionaire visa. So if you have $1 million to invest in a US enterprise, or for the thrifty amongst you, if you have 500,000 that you can donate to a so-called regional center that's been designated as a special vehicle for investment, you can obtain one of these visas. So this is a long explanation of this slide. But what this slide is designed to show you is that if you are a millionaire from mainland China, you still have to wait for 5 years to get a visa to enter the United States. Similarly, if you are an individual with an advanced graduate degree and good professional standing from India, you have been waiting for 11 years to get your visa application adjudicated. So the visa bulletin here demonstrates just how long these waits are for these categories of immigrant visa. Kit, you're muted.
And what Stella was just discussing is the underlying law, right? What you would see in the US code that explains how visas are allocated, who's entitled to them, right? What we would consider law. But President Trump has used the power of his office to issue executive orders to further establish policies that are very much working against potential immigrants of color, including people who you might think wouldn't be a problem, workers, right? People who are becoming lawfully to the United States. I think that's something that's worth emphasizing. Everything that Stella and I are talking about in this presentation is how do you get someone to come to the United States lawfully to work, with permission, with a visa, with the opportunity. And we're saying there are huge hurdles. So if you have legislative, congressionally based hurdles, you also, under President Trump, have executive orders that are problematic. And one of them is the Buy American, Hire American executive order that President Trump signed. When he announced this policy, and it was something that he was stumping on back in 2016. If you'll throw your mind back to 2016, I know two, political giant moments have since passed, but going back there, he was very concerned about what had been going on at Walt Disney World in Florida. And the Disney Corporation had decided to essentially outsource its IT work and left a bunch of sort of skilled American workers without jobs, and they were replaced by foreign nationals. And Trump was very upset about this. And this is sort of part of his policy, and his response was this executive order. And he repeatedly referred in this order an intention to further limit visas to Indian and Chinese nationals working in STEM fields. So exactly those people that Stella just showed you already have, as a result of the congressionally passed law, a very long wait time. We have superimposed on that an executive order, further making it difficult.
But that wasn't enough. And so in June 2020, the Trump administration issued a further proclamation, the proclamation suspending entry of aliens who present a risk to the US labor market following the coronavirus outbreak. Now, remember at this time, because of the coronavirus outbreak, there are already presidential proclamations in force closing the borders to prevent individuals from countries with high prevalence rates of COVID-19 circulating in the country from traveling to the United States. What this proclamation did was just suspend the issuance of almost all labor-based migration for the next 6 months. The proclamation barred the issuance of H-1B and H-2B non-immigrant visas for foreign workers. What that means is we just in the previous slide talked about employment-based visas for green card holders coming here permanently. H-1B visas are usually provided on a rolling 3-year basis. So you're agreeing to work for a US employer for 3 years. This proclamation barred the issuance of those visas, even to people in countries where there weren't at that time travel restrictions in force for travel to the United States, such as, for example, Taiwan. The proclamation also barred the issuance of L visas, which were for intra-company transferees. So if you worked for a US corporation overseas, if you work for Intel, if you work for Google, if you work for Facebook, you could just transfer over in the normal course of things to a coordinate position in a US office of the same corporation. The proclamation barred that. It also halted the issuance of so-called derivative visas for the spouses and minor children of any individuals who are currently living in the United States as holders of H-1B and H-2B visas. And the effect that this had on the spouses and children of immigrant workers was devastating. And then in October, this proclamation was followed by new rules, which were rushed through on an emergency basis, barring the issuance of particular kinds of visas to specifically skilled workers and increasing the salary threshold for sponsorship for H-1B visas. On average, it raised the salary threshold from approximately a salary of $80,000 per annum to over $200,000 per annum. And as you might expect, there was an uproar in industry, and Caltech, along with the Chamber of Commerce of the United States, sued the Trump administration in federal district court in California. And just yesterday, US District Court Judge Jeffrey White ruled that these changes that had been made by the administration were impermissible because the emergency rulemaking process was incompatible with the requirements for notice and comment under the APA. And so as soon as Judge White's ruling came down, the approximately 600,000 people who've been waiting in limbo for the last 6 months had a little celebration. But truly, this is just the tip of the iceberg of what's been happening over the last 4 years in this area.
We want to give a nod to our colleague and friend, Professor Ming-Soo Chen at Colorado, who has talked about this kind of executive order and rulemaking, and even truly the legislation that we go back to in 1965, as being colorblind. Like ostensibly it's colorblind. When we say hire American, it's just hire American. We don't care who it's going to affect. It's theoretically just about protecting American workers from foreign competition. But once again, it's an immigration policy, the statute itself, plus these executive orders that I've talked about and Stella's talked about, plus the new regulations, whether they manage to stay in place or not, they have really disproportionate effect on what we would call the oversubscribed countries and regions of origin. And just to highlight the first line on this slide, it's the same slide that you saw before, but as it turns out, sort of across the board, whether it's on the basis of employment, which is our focus, or family, which is another way in which many people come lawfully to the United States, if you are coming from China, El Salvador, Guatemala, Honduras, which are called the Northern Triangle, India, Mexico, Philippines, odds are you have to wait significantly longer than someone coming from Australia, the UK, another nation.
And it's also worth saying that there are other, perhaps less obvious, but no less devastating ways in which the Trump administration has used its regulatory powers to restrict employment-based migration by people of color. Because immigration lawyers and teachers like to divide immigration into two neat categories of family and employment-based visas. But of course, the boundary is much more porous. Many businesses are family-run firms that employ immigrants and sponsor them either for family-based visas or employment-based visas, or a mixture of the two. And of course, any immigrant workers who come to the United States with their families have to deal with family-related criteria. One of those one criterion since 2009 has been since 2019 has been the new rule governing inadmissibility on the basis of becoming a public charge. This is a rule that goes back to the 19th century, when the United States didn't want indigent immigrants who would arrive and be penniless and resort to crime or prostitution or other unsavory ways of grifting and earning a living. This rule was introduced to deter individuals who were indigent and penniless from seeking passage on ships and coming to the United States. And for over 100 years, it continued to be part of the immigration laws and was largely unremarked upon, apart from in foundational immigration law and policy classes of the kind that Kit and I teach. But in 2019, the Trump administration added a variety of new restrictions on who could apply for lawful permanent residence in the United States, including heightened income burdens for those with more dependents, and new creditworthiness tests, hence our slide, based upon data collected by commercial credit agencies. And surprise, surprise, this new policy had an outsized impact on immigrants of color. In fact, data collected by the Pew Research Center showed conclusively that non-white immigrants, in contrast with their peers from Europe and Canada and Australasia, are likely to have larger families and fewer financial records that are accessible to credit checking entities in the United States. If you have never lived in the United States, you are not going to show up in an Experian or Equifax or TransUnion search because you have a credit history and record in a foreign nation, or perhaps your family's wealth is based in land or some other kind of tangible holdings that again will not register with a US-based credit checking agency. However, individuals from Western Europe who have equivalent systems of credit checking and credit worthiness were much more readily able to prove that they meet this standard of not becoming a public charge. And so these new rules basically added an additional hurdle for immigrants of color seeking employment-based visas.
And now we come to what is my favorite slide, and I hope you will enjoy it too. A little explanation. Stella mentioned earlier, people who come to the United States temporarily to work on something called an H-1B visa. Typically, I find if people aren't immigration folks, they nonetheless have heard of the H-1B visa because it is the only one, I believe, that gets mentioned on the news to some extent or another. And the context you've probably heard it in is Intel or Facebook or some technology company, or even the Disney story that I mentioned earlier with the incoming accounting people or IT people working in the United States. They're typically working on what we call this H-1B visa. It's for members of a particular profession. Well, the interesting thing about people with professional identities and professional jobs is that they frequently marry people who are also professionals who themselves have professional identities and professional jobs. And the question is, what should happen with these spouses who come along with their partners who are hired for a job in the United States? Should those spouses stay at home? That's our top slide here in the meme. Or should they be given the authority to work? And EAD just simply means Employment Authorization Document. And what the Trump administration announced, or another facet of what they were intending to do, was to eliminate the opportunity for spouses of H-1B non-immigrant visa holders to work in the United States. So the Trump administration was interested in taking these professional, typically women, typically South Asian women, because South Asian women were 94% of the H-1B, of the H-4 visa petitions. H-4 is the derivative, the family, the follow-along spouse. It also applies to children. And this proposed rule is to say, we don't want competition from realistically these women. So again, colorblind, gender neutral, we just don't want competition from spouses who themselves weren't hired to work in the United States and brought here, but just happen to show up and happen to have skills. But the reality of how it plays out is that it is gender-based, it is a rule that affects women, and it is a rule that in particular affects South Asian women.
And so in our time together today, in the 30 minutes we've had to talk to you, we just wanted to point out that the paradox of employment-based immigration law here in the US. Since 1965, this country has purportedly sought to eschew racial exclusion in employment-based migration, but it has consistently failed to deliver on that promise. And since January 2017, the situation has become increasingly evident. Each attempt at regulatory and sub-regulatory rulemaking by the Trump administration has had an intentional and disproportionate effect on immigrants of color, curtailing the ability of talented individuals like the ones you see on the slide from around the world to flourish personally and professionally by contributing to the American business community.
And that, of course, raises the $64,000 question that is no doubt in your minds as we convene here in early December. And that is, what might Biden do, right? What are things going to look like when he takes office in late January? And we can leave this largely for the Q&A in case you have questions, but I thought I'd give you some basic, really quick thoughts, which is, it is easy to overturn very quickly an executive order. So hire American, fire American, that's an executive order. That's easy to take care of. What will be much more difficult is the number of and sheer volume of regulations that have been passed under the Trump administration to make it difficult to bring in employment-based migrants and employment-based migrants of color. Turning those over requires all of that notice and comment and administrative fun that you may not have thought about since law school. And then, of course, back way in the distance, you can think about what would Congress, again, a divided Congress so far, how much can they weigh in to change the substantive law?
And so I think with that, we will move on to your questions. We're excited to speak with you about this topic, and we're looking forward to the perspectives that you have on what is for us one of the most important and pressing issues of 2021.
Thank you, Stella and Kit, for talking to us about this really important topic. So if you have questions, you can type them into the Q&A function in the Zoom webinar. If they're anonymous questions or really short, I'll just ask them myself. If they're longer questions that aren't anonymous, I'll unmute the person asking the question so they can ask the question in their own words. So just to get us started and thinking about some of the topics that you were talking about, one of the questions that came to mind for me is the extent to which it strikes me that immigration law is maybe one of the highest peaks of where racism is embedded in U.S. law. So that definitely strikes me. I'm curious about your thoughts on that. And then also the extent to which the United States is the same as or different from other countries with this regard. In other words, are we uniquely racist in this area, or is this an area in which there's a lot of this type of conduct and behavior among other countries?
Shall I take that one?
Law, that's you.
I am the editor of the Oxford Handbook. I'm one of 3 editors of the Oxford Handbook on comparative immigration law. So this is a topic that I have been thinking and talking a lot with my fellow editors about as we commission essays on this very topic. The short answer to Professor Rantanen's question is, it depends, because immigration law is inherently racialized, but how that manifests looks different in different nations. So in immigration-based nations, almost all of the so-called nations of immigrants, whether it's Canada or Australia, have a pretty bleak history. The White Australia policy, which guaranteed the migration only of white immigrants to Australia until the 1960s, is a classic example. The Canadian quotas privileging migration of French speakers to Quebec, and they just so happen to all be white French speakers from France, is another example. In Western Europe, with a colonial legacy, the racialization of immigration law looks different. In the United Kingdom and France, priority in visas was given to individuals who were nationals of former colonial possessions. And here in the UK, we still have something called a British Overseas Territory Citizen, which grants you certain rights to live and work in the United Kingdom. But the United States is remarkable because, unlike the other so-called migration nations, it has not moved forward from that legacy. It still has a system of migration explicitly based on country and ethnicity-based quotas. And so that's remarkable. In Canada and Australia, for example, they've now moved on to points-based systems, which you may have read about in the newspaper. Periodically, people say, we should have a great points-based system like they do in Canada, like they do in Australia, which privileges individuals with certain skills. But of course, underlying the colorblind and neutral points is a system of privileging things that often correlate with white identity. So the US, it is an outlier because it's explicit about race and national origin as a determinant of quotas for entry, but it's far from unique in terms of privileging highly educated white immigrants.
So we have a number of questions here. I'm going to just start with this first one. What would you both like to see in the way of employment immigration reform?
That's very exciting. I don't have a good answer to that. And I'll give you one example that I think that we need more nuance, to be honest. And I think it's difficult to legislate with nuance. And I'll give you one example. Stella mentioned this idea of giving H-1B visas only to the people who are making the most money. So if you have 10 people who want to come to the United States temporarily, let's only give the visa to the person making $200,000. They are the least likely to displace an American worker. Where someone who is coming getting paid $65,000, maybe they're going to displace an American worker. And I think that the really clear example of that, just to go back to the same one I used before, is when Disney made the decision to no longer have an in-house IT business. And so they fire a whole bunch of pretty high earning, middle-class Americans and replace them with foreign workers who are clearly being paid less. So a system where you only give the visa to the highest paid would certainly work in that limited context. And I think that's the context that most people think about. Having lived for a significant time in North Dakota, 7 years, I can tell you that my fears are really deeply steeped in rural America for a large part, and in no small part with the inadequacy of rural health care options. And the fact was, if we had a medical issue that was of any urgency, any complexity, I would be grateful if I only had to drive 4 hours to get to a doctor, and I would be, it would be normal if I had to drive 8 hours one way. And so you could use the same visa to bring somebody to work in Grand Forks, North Dakota, and they could be paid a Grand Forks, North Dakota wage that would be appropriate, say $80,000. But that wouldn't be, if we set a rule that just says the richest, highest paying jobs are going to get it, it's going to be a detriment to rural America. So I think that there has to be something, even if it was a system of the highest paid for that zone, for that area, for the urbanity of it. I mean, we could even do it in systems of, how dense is it? How urban is it? But those are questions that I think most people are just ignoring because it is too nuanced and too difficult to think about writing to that level of minutia. But I think it's the minutia where things really can happen and are important.
Here's a question about student visas. What do you predict happening to student visas, especially the restrictions imposed during the summer of 2020? I realize it's a little off topic, but I think that there's a couple people here who would love to hear your thoughts on that.
So I'll start with that because I want to put what's happened with student visas in context. So Kit at the end of our talk explained how the Trump administration has made countless changes to immigration law. They've made over 400 changes through sub-regulatory and regulatory rulemaking. But in addition to the changes to the law, they've made some really big changes to the institution and administration of the law. In other words, they've massively increased the processing time and introduced new hurdles to processing visas. And part of the big issue with student visas, including the restrictions that were actually imposed and the restrictions that they attempted to impose in the summer of 2020. And for those of you who haven't followed this closely, the most remarkable proposed change that didn't go into effect because it was enjoined by a federal district court in Boston was that during the COVID-19 pandemic, when so many students, including our own law students, are taking classes online, there is ordinarily a requirement that students in the United States on F1 visas or exchange visitors on J1 visas take a certain number of credit hours with their butt on a seat in a classroom. And taking classes online doesn't meet that requirement. And from May through to the summer, that specific requirement was waived in the interests of public health and public safety to enable students to remain in status and not have to return home. The administration tried to change that. They were unsuccessful. But what they were successful at doing was stopping the issuance of visas at consulates overseas. And that administrative backlog has nothing to do with the text of the administration laws or the regulations, and everything to do with the funding of the infrastructure that processes visas, whether it's the National Visa Processing Center in Portsmouth, New Hampshire, or the relationship between consular officials and DHS officials in embassies and consulates overseas. This is a really significant problem for student visas. And so my big hope is with a new administration that is more committed to the enterprise of international education, there will be more funding and more instruction to remove these, if you like, this invisible wall that's blocking a lot of student access to the United States. So that's my prediction and my hope. I don't know if Kit has anything to add.
So I do, I appreciate the question. I've actually written and done some empirical research on international students in a couple of pieces. And I would say my outlook is far bleaker. And the bleakness of my outlook comes from a different place. So let me just start by saying, I think students and asking about students is really appropriate and in line with discussion of employment, because today's students in the United States are future employees in the United States, right? The goal is, or for many, we have a system set up where you can study in the United States, then you're allowed to do a little bit of work under something called OPT or something. There are opportunities to work as part of your education. And then frequently, that is how you get to know an employer who will then file for that other kind of visa, like I had mentioned, the employment-based H-1B visa, and then maybe that turns into the permanent employment type work that Stella was talking about earlier. So it's a chain, right? A chain from studying all the way to staying in the United States as a worker. I think that the Trump administration has really damaged our reputation with international students. And because if there is any hint that you won't be able to stay in that chain, then why should I study in the United States when I could study in Canada, where there is a very, very clear chain, right? Where students themselves, I've taught students who got residency or permanent residency in Canada as a student, right? Not even as a potential employee or somebody who's already working. So there are other countries that are just much more open and willing to make clear the future path for international students. And I worry that we do not do that. And we're not committed to doing it. And the past 4 years of vilifying immigrants of all kinds is going to be really, really hard for universities to dig out of.
So here's a question from an anonymous attendee. Does it follow from your discussion that all limitations on immigration are questionable?
The short answer to that is, of course not. In my former life, before I was a law professor, I was a foreign service officer, and there are exceptionally sensible reasons for having limitations on migration to do with national security and public safety, and also internal labor markets. You have to be pragmatic and sensible about it. But I don't think there's any justification for having a system of laws that is structurally racist. I think they're two very separate things.
I agree. And I think also numerically, we are chintzy compared to any other country in the world. One of my favorite apps, I believe it still exists, it's like Map Challenge or MapQuest. And you can put up the United States and compare it to the geographic, the boundaries of another country. And you can also compare by population. And if we take a look at how many immigrants we take compared to other countries, compared to how much money we have, compared to how much land we have, I think we're shooting ourselves in the foot by not expanding the numbers of people who we accept every year. So I firmly believe we have room in the United States for many, many more immigrants. But absolutely, we want to make sure that they are immigrants who are going to benefit the United States. That's sort of part of the whole system is, the kind of what's in it for us, even if what's in it for us is, when it comes to asylum and refugees, a totally different topic, but more about global burden sharing than it is about sort of individual benefits that you might get from an employee or somebody like Stella who mentioned, bringing $1 million to the United States, I think should be a slam dunk for anyone.
All right, we have time for one more question. This one's from Professor Prince. Can you speak a little about the reaction or role of the companies themselves? Are they pushing back against or supporting these changes publicly, behind the scenes?
This is a great question. And of course, companies don't act monolithically. So there's a variety of different responses from different corporations. In terms of the immigrants supporting companies, the most prominent activism has been with respect to young DACA recipients and dreamers. And a number of very high profile employers have gone to bat, have made public statements, even when the government said that it was scrapping the DACA scheme and people would not be able to renew their DACA who were existing DACA recipients. A number of very well-known national Fortune 500 companies came out and said, we will continue to employ our DACA recipient employees. So that's a very high-profile example. Other corporations such as Chobani, the yogurt people, wanted to bring refugees in via employment-based visas to provide employment in the United States and circumvent the Trump administration's lowering of the refugee cap by offering employment in their factories in the United States for refugee workers. So there are some progressive or potentially progressive, I'm not quite sure how you describe these corporations because not all of their actions, of course, fit that label, who, at least in the immigration arena, have signaled a tremendous pushback against the Trump administration. But of course, there are many other corporations who are very closely tied to this particular administration, are donors to the administration, and have made a lot of publicity out of the Buy American, Hire American valence. And so that has formed a part of their corporate brand. And they have been very supportive of the initiative, letting the public know about just how many American workers' jobs have been saved by them moving their plant to the state of Michigan, for example.
Yeah, and as you might imagine, I mean, you're going to have a really different reaction based on how settled the corporation is. So a company like Facebook is out there fighting and saying, hey, we need H-1B workers, we need H-1B workers, we need H-1B workers. While they are against the idea of giving them only to the highest paid workers, on the other hand, they're far less affected than a smaller company, again, in rural America, or even just a mid-level, company would be in terms of responding to that kind of change. If they desperately need the H-1B workers, they can pay them $200,000, whereas other companies can't. And they may see that as just another way of pushing out other smaller companies. So there's the same kind of corporate shenanigans that affect everything from antitrust to, where you're incorporating, are certainly come into play when people are talking about immigration.
Well, we're out of time, unfortunately, so I'd like to thank both of you for joining us. I really appreciate it, and I'd like to thank our audience as well for joining us today and for some of our other speakers this semester. If you missed any of our speakers and you'd like to watch their talks, they're available at the Innovation Business and Law Center's YouTube page. You can find a link to that on our website, www.ibl.law.uiowa.edu. And with that, we're going to close out the semester, close out our speaker series. So I hope you'll join us next semester. We have a new series that we're developing, and we'll see you then. So with that, I'm going to say bye-bye. Thank you again, Professors Johnson and Elias, and I hope to see you all in the spring.